Joining us right now is Mr. Ujjwal Nikam. Mr. Nikam, thank you very much. First of all, my first question, the Supreme Court judgment is now out. The next date of hearing we know is the 11th of July, but some interim relief has been given to the rebel MLAs. What's your view? How do you look at this?
Today's order is neither to say that one party is win the thing or one party is lose the matter. I'm saying so because the main grievance of the MLA's Shinde's group that the Deputy Speaker has no legal right to issue notice to disqualify them because they have already brought no confidence motion against him. And their second contention was that the government is in the minority and therefore the Deputy Speaker has no legal right to issue such type of order. The Supreme Court has issued a notice to the Deputy Speaker of Maharashtra Assembly as well as the whip of the Shiv Sena and asked them to tender their affidavits in respect of the allegation made by the petitioner MLAs. And the Supreme Court is going to consider this matter on 12th July. So till this time, the position is as it is. And I must say that, which of course I was expecting as a student of law, that there should have been some orders, speaking orders, but Supreme Court must have thought that in order to have the principle of natural justice, the other side must be heard in detail, though the other side in the state of Maharashtra had appeared. But Deputy Speaker, especially in the whip of the Shiv Sena, must be heard in person by their affidavits, and therefore they have given that opportunity to them.
Sure, sure. Mr. Nikam, Maharashtra government has said that since relief has been given to these rebel MLAs, they anticipate that MLAs will then demand for a floor test, and a floor test must also be put on hold till the 11th of July because this disqualification bid has been put on hold till that date. What is your view on this? Is this a just demand?
Sanket, in the first place, I would say there is no such relief has been granted to the Shinde's group, firstly.
Okay.
Because they have extended the time limit. In fact, the Shinde's groups had a grievance that notice should be stayed because the Deputy Speaker has no legal right. Now, you are certainly right that the government of Maharashtra has made a very fervent apprehension that in the meantime, no person should bring any no confidence motion against the government. But Supreme Court said that that situation has not come and therefore we can't grant any relief to them. But of course, in the interim period, suppose in case if anybody takes steps for bringing no confidence motion, certainly the state of Maharashtra can ventilate its grievance in the Supreme Court. Now you have asked me whether it is fair or not, just or not. I don't want to comment upon that because the Supreme Court did not grant any interim relief either to the government of Maharashtra or to some partial, I would say, relief in the sense they have extended the time limit for giving their response and reply to those MLAs.
Would you like to tell us a little, Mr. Nikam, of what the legal options are ahead for these rebel MLAs?
Sanketji, this is a really debatable issue whether the MLAs, those MLAs can be rebelled or not. Because one has to see when the Deputy Speaker has issued a notice and when these rebel MLAs has issued a no confidence motion against the Deputy Speaker. Because that date will be the crucial date. Assuming for the sake of the argument, if the Deputy Speaker had issued notice, show cause notice, as to why you should not be disqualified, before the no confidence motion later brought against him, then certainly the Deputy Speaker will be justified in saying that his notice is earlier notice than the rebels' notice. Rebels' notice is only the counter-attack. Now, whether they have obeyed the party's whip or not, that is again a very crucial issue. And whether the government is majority or minority, that can be decided only in the Assembly's house by the floor, in the floor test.
Okay. Mr. Nikam, there were also questions on a division of power between the legislature and the judiciary. That in this case, since only notices have been issued, the courts must ideally not step in. Where do you stand on this issue of division of power?
I do agree with you. In fact, I was expecting that at least principle of natural justice, the Supreme Court had issued a notice to the Deputy Speaker and the Whip of the Shiv Sena, but they should have kept the matter tomorrow. Why there was a delay? See, this 11th July is a very long period. Now, in fact, the many ministers, they have, the Chief Minister has taken their portfolios of many ministers, and some ministers are having now 10, 15 portfolios. So, Supreme Court should have considered this position also because of these rival contentions. But unfortunately, this has not happened. That much I can say. But yes, being a citizen of the state and the country, I was expecting that why there was a delay.
My final question, Mr. Nikam, you also agree that neither the courts nor the Governor's House nor a resort in Guwahati, ultimately whether the Maharashtra government stays or goes, whether it enjoys a majority or not, is going to be decided on the floor of the House, the Assembly.
You are absolutely right. The authority or the jurisdiction to decide whether a particular government is in majority or minority, that can be decided only by floor test. And that situation, let us see when it will come.
All right. Ujjwal Nikam, many thanks for joining us. Thank you so much.